Okay, I was just watching a video about the new rules of Pentagon for reporting. So a lot of reporters are no longer reporting from inside the Pentagon. Okay, I put definition of protected disclosure. Making protected disclosure is sometimes called whistleblowing or reporting wrongdoing in the workplace. A protected disclosure, disclosure by a worker or information about a relevant wrongdoing which they become aware of in work-related content. Okay, what is protected disclosure in federal whistleblower case? Okay, so there's a lot of things you can find if you ask the right questions, and I think the simple ones are the right ones. Under a federal whistleblower law, a protected disclosure report of wrongdoing or misconduct made by an employee or contractor to the federal government. This disclosure must be made in good faith. In addition, it must concern several specific types of allegations, such as violations of law, rule, regulation, or other legal requirement. You're probably reading this article because you're consider blowing the whistle on your employer. You may be very well feel overwhelmed, scared, anxious, but the good news is federal law provides you protections for whistleblowers. More than that, you don't have to fight the battle alone. Contact a qualified federal employment attorney for assistance today. First things first. What protection is there for whistleblowers? Two legislative cornerstones work together to protect whistleblowers. The first Whistleblower Protection Act, and the second is a Whistleblower Protection Enhancement Act. The WPA, Congress originally passed the WPA in 1978, but has been updated several times, and the WPA specifically protects federal employees who make protected disclosures about covered misconduct. It's protected retaliation against employees who disclose things like waste, fraud, abuse of authority, or violation of laws or regulations. Finally, the WPA furnishes process for whistleblowers to file complaints to the Office of Special Counsel to seek remedies for retaliation. Thanks to the WPA, federal employees can't take adverse Thanks to WA, federal employers can't take adverse personal actions against employees who make protected disclosure. And what adverse personal actions? This they include, but aren't limited to, terminations, demotions, suspensions, reassignment to a different job. If employee experiences retaliation, they can file a complaint with the OCS within 45 days of adverse action. The OCS will then investigate the complaint. If it finds evidence of retaliation, it can take corrective actions, including reinstatement, payback, and attorney's fees. The WPA in 2012, Congress passed the Whistleblower Protection Act, which strengthened the legal protections for federal whistleblowers. The WPEA classified and expanded the definition of protected disclosure, making it easier for employees to qualify for whistleblower protections. The WEPA also expanded the WPA scope to cover more employees. Newly covered personnel included Transportation Security Administration employees and intelligence community employees. Even government contractors receive coverage under the WPEA. The WPEA provides several key additional protections for whistleblowers. For one, it adds a mechanism for whistleblowers who experience retaliation to get temporary relief. The WPEA also empowers a whistleblower to request a stay of adverse personal action while their complaint is pending. That means they can stop whatever is happening, firing, demotion, they could stay, same pay, same job. If the OCS determines that the employee has substantial likelihood of success on the merits, it can request they receive reinstatement while their complaint is pending. Yeah, I just said that. Sorry. So what is a protected disclosure in a federal whistleblower case? Now that you know more about key whistleblower legal protection, let's dive into the issue we mentioned at the beginning of the article. Protected disclosure or release of information by federal employees that demonstrate evidence of a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, a specific danger to public health and safety. These categories provide sweeping protections to all kinds of statements. Protected statements can be made to a supervisor, inspector general, or even Congress. However, many disclosures still fall outside the definition of protected disclosures. For instance, a personal grievance or report of general workplace dissatisfaction probably won't count as protected disclosure, nor will a general complaint unrelated to illegal activity or safety concerns. These examples of protected disclosure to help drive the point home, let's imagine three potential real-world scenarios involving protected disclosures. Example 1, Jay is a federal employee working for the Department of Agriculture. One day she discovers a supervisor has been illegally selling government-owned land to a private company for personal gain. Jane reports this conduct to an agency's office of Inspector General. This would count as a protected disclosure under the WPA. Example 2. John is an applicant for a position with the Environmental Protection Agency. After the interview, he stumbles upon evidence that high-ranking officials in the agency have been tampering with data to downplay the impact of hazardous chemicals on public health. John decides to share this information, a protected disclosure, with the agency's Office of Special Counsel. Example 3, Sarah works for the Department of Defense. She is assigned to project that she believes a process of a serious risk to national security. She brings it up to her supervisors first, but he orders her to stay quiet. As a union member, she decides to contact a union steward and file a grievance to disclose the information. You don't have to fight wrongdoing on your own. Let us help. Legal assistance is crucial if you are considering making a protected disclosure. It's even more crucial if you think you are facing whistleblower retaliation. Many wrongdoers in the government resort to intimidation and threats to protect themselves, and often a whistleblower complaint procedures become complicated quickly. Don't go it alone. Trust our team at the federal employment law firm of Aaron D. Wising, PLLC. Our attorneys have extensive experience and handle whistleblower complaints before the OCS. I'm sorry, I'm not like advertising for this guy. I'm just letting you know what's there, okay? There's a lot of things people are being told to do that they shouldn't be doing. And they're saying, hey, well, if I don't, I'll lose my job. That doesn't cut it. Okay. So there are laws for whistleblowers, and that's what's going on right now. They're trying to keep people from being whistleblowers. If you understand, the FBI, the DOJ, the IRS, every public servant takes the oath of public service, okay? And that's taking oath and putting the Constitution first, okay? So, let's go. I want to do it. There's penalties for every law. Penalties for violating oath of office can include removal from office, criminal charges such as fines, imprisonment, disqualification from future office, and loss of benefits. The specific consequences depend on the nature of the violation of the office held and the relevant laws, which can include impeachment, recall elections, or other legal mechanisms. Simply put, if you aren't living up to the oath, you aren't fit for public service. Okay? It's illegal to violate the oath. The oath is a law. Okay, let's. Uh, let's just say put versus the oath. Okay. An individual solemn oath to a higher authority, such as the Constitution, takes precedence over personal loyalty to a political figure. Public servants in the U.S. at all levels of government, including elected officials, military personnel, and federal employees, swear an oath to support and defend the Constitution of the United States. This loyalty is owed to the rule of law and the nation's founding principles, not any single person or political party. Okay, so the oath is always to the Constitution first. I seen a young gentleman, he had a military uniform on saying that, his oath is, yes, first to the Constitution. He says it, but then he says also to the commander-in-chief and the higher-ups. It mentions the Constitution. The oath is always to the Constitution first. Okay, the principle that the oath is paramount to loyalty, the principle that the oath is paramount to loyalty to a leader was intentionally established by the nation's founders who were wary of concentrated power, a bulwark against tyranny. The framers of the Constitution deliberately required an oath to the Constitution, not to the president, because they feared the potential for a U.S. president to act like a king. Loyalty to a system, not a person. As a former chairman of the Joint Chiefs of Staff, Mark Milley, said, military service members take an oath to the Constitution, not a wannabe dictator. U.S. military academies have recently re-emphasized the distinction in their training. The ethical conflict. Remember, violating an oath is also, that's an ethical violation, okay? So you can file for that, ethics violations. A conflict between loyalty to a politician and one's oath is classical ethical drama that can challenge an individual's integrity. Duty versus loyalty. While loyalty to a politician, a political team or leader is common sentiment in politics, it cannot outweigh the sworn duty to uphold constitutional principles. When the two conflict, an individual's integrity is tested. Distorting public duty, allowing personal or political loyalties to influence official duties can distort a public servant's performance and is considered a breach of their ethical obligations. Okay, let me reiterate that. Distorting public duty, allowing personal or political loyalties to influence official duties can distort a public's performance and is considered a breach of their ethical obligations. The honor system. While some states have strict penalties for conflicts of interest, others operate largely on the honor system. This leaves voters wondering why private loyalties influence public decision making, which is unethical to put personal gain before the public gain. That's violating the oath. The public interest comes first. If you read the preamble and the rules of professional conduct, all lawyers are required to put what's in the public interest. To do what's in the public interest, not in self-interest, parochial interest to the bar. It's thus making it illegal to put personal interest. The public interest comes first. It's a mandate. Okay, I did that. I went over that in one of my other videos. Okay, recognize the conflict. Public officials are ethically required to recognize when a conflict of interest exists. Report the conflict. In many cases, they must report potential conflicts, for example, fiduciary duties. Fiduciary duties often requires disclosure of conflicting interest. An official may choose to resign from a position rather than violate their oath. For instance, former Missouri Secretary of State Jay Askoff suggested he might not be able to take the gubernatorial oath if voters approved an abortion rights measure, indicating he might need to leave office if his sworn duties conflict with personal views. Loyalty oath, U.S. Constitution. Yeah, see, so the oath comes first. Okay, let's okay. In the U.S., putting loyalty to a politician over the Constitution can lead to severe penalties, including impeachment, removal from office, fines, and imprisonment. Penalties are not specified for disloyalty itself, but rather to specific criminal offenses they may result from such an action, such as seditious conspiracy or obstruction of justice. The penalties vary depending on whether the individual is a public official or a private citizen and the severity of the legal acts committed. Penalties for public officials. Public officials swear an oath to support and defend the United States Constitution. Violating the oath can lead to political and criminal consequences. Removal from office. Federal officials, including the president, can be impeached by the United States Representatives and removed from office by the Senate for treason, bribery, or other high crimes and misdemeanors. State and local officials can also face removal for impeachment on other state level processes. Disqualification from future office is part of an impeachment conviction. The Senate can vote to bar an official from holding any future public office. Section 3 to 14 also prohibits individuals who have engaged in insurrection or rebellion after taking an oath to support the Constitution from holding future office. Federal criminal charges, specifically legal acts committed in the service of a politician, can lead to federal charges. For example, laws cover advocating to overthrow the government. It is a crime for a federal employee to advocate for the overthrow of the U.S. Constitution forms of government. Penalties can include imprisonment or both, as well as removal from office. Seditious conspiracy, conspiring to overthrow the government or oppose its authority by force, carries a prison sentence up to 20 years and or a fine. Obstruction of justice. Actions intended to obstruct a lawful proceedings such as election or congressional hearing can result of imprisonment up to 20 years. Federal ethics laws. The breach of public trust can also lead to fines and in some cases imprisonment, especially in the case of corruption and bribery. Penalties for private citizens. A private citizen who puts loyalty to a politician ahead of the Constitution can face federal charges if their actions rise to the level of criminal offense. Seditious conspiracy. As with officials, private citizens who conspire to use force against the government can be charged with seditious conspiracy and imprisoned for up to 20 years. Treason. This is the most serious charge and is narrowly defined in the Constitution as leveling war against the United States or adhering to their enemies, giving them aid and comfort. It is extremely difficult to prove, has rarely been prosecuted. Eviction for treason can result in imprisonment for at least 5 years, a minimum of $10,000 fine, or death. Other related charges, depending on specific actions, a person can be charged with other federal crimes such as inciting a riot, assault, or destruction of government property. The key distinction: the court is not simply professing loyalty to a person over the Constitution. Okay, the key distinction: the core issue is not simply professing loyalty to a person over the Constitution. The penalties apply what that must be misplaced loyalty results in specific overt criminal acts violate or federal or state law. The penalties to public officials are often more severe because they involve a sworn oath and a greater breach of the public trust. Okay, what happens to officials that violate their oath to the Constitution? When elected officials violate their oath to uphold the Constitution, they breach the very foundation of their service to the American people. The U.S. Constitution is clear in its demand for government officials. Their first and foremost duty is preserve, protect, and defend the Constitution itself. Any deviation from this duty strikes at the heart of a nation's integrity and the freedoms we cherish. But what are the consequences for such a violation? These vary depending on the nature of transgressions and the office held. The Constitution itself provides mechanisms for accountability, while federal and state laws further reinforce these standards. There's an overview of what happens when an elected official fails to uphold the oath. Impeachment and removal from office. The most direct constitutional remedy for federal officials, including the president, judges, and other civil officers, is impeachment. Article 2, Section 4 of the Constitution outlines this process, stating that the officials can be removed for treason, bribery, or other high crimes and misdemeanors. Impeachment begins with the House of Representatives, and if approved, is followed by a trial in the Senate. If convicted, the official is removed from office and may be barred from holding future office. Impeachments include public servants accountable, preserving the rule of law, ensuring no one is above it. Criminal and civil penalties. Beyond impeachment, elected officials who violate the law may face criminal charges, including violation of federal statutes. Acts such as bribery, fraud, and abuse of power can lead to prosecution with potential penalties ranging from fines and imprisonment. Not only do these charges uphold justice, but they reinforce the principle that elected officials are not immune from laws they enforce on others. I love the way they said that. Censure and reprimand. In cases where elected officials' actions do not rise to the level of criminal activity or impeachable offenses, Congress or state legislators may issue formal censures and reprimands. These are public condemnations of misconduct, tarnishing the reputation of the official and signaling that their behavior is unacceptable to colleagues and the American public. When censure doesn't carry legal weight, it is a powerful tool in shaming and publicly holding officials accountable for their failure to uphold their constitutional standards. Loss of public trust and electoral defeat. Violating the Constitution often leads to loss of public trust. Elected officials who betray their oath may face backlash from their constituents who expect them to uphold their responsibilities. As we've seen times again in U.S. history, voters ultimately serve as the strongest check on government. In a respective democracy, the ballot box allows people to remove those who fail to honor their commitments. Public scrutiny, bolstered by the media and the grassroots movement, play a critical role in upholding officials accountable to their oaths. State remedy. State-level officials who violate their oaths face similar consequences as federal officials. Many states have provisions for recall elections, where citizens can directly vote to remove elected officials before their term ends. We should have that on the federal level as well. Additionally, state laws may provide for impeachment, prosecution, or disqualification from holding office. The officials' actions breach the public trust. Disqualification from future office. Seen impeachment trials, one of the key consequences for violating the Constitution is barred from holding future office. This prevents those who abuse their position, disregard their oath, or returning to positions of power. The constitutional framers were all aware of these dangers posed by corrupt or irresponsible leaders. These safeguards ensure they cannot repeat their offenses. The role of the people. Ultimately, the Constitution empowers the American people to hold their elected officials accountable. Elected officials are stewards of the Constitution. If they betray their oath, they betray the very foundation of liberty. America's founders understood that public virtue, that accountability are essentially maintaining a free republic. Our responsibilities as citizens ensure the entrusted power are held to the highest standards. preserving the constitutional principles and define our nation. Our system of checks and balances, electoral process, the rule of law, all play a role is ensuring that those who swear to the oath uphold the Constitution do it faithfully. When they fail, it is not only the government but the citizenry that must demand justice. The 917 societies on a mission to educate our youth about our Constitution and citizenship. We cannot defend and protect what we do not know. We cannot hold our representatives accountable if we do not understand what they are sworn to uphold. To learn about our mission, visit our website. Okay, people, I didn't write any of this. I'm just reading it to you, okay? Okay. So, no, you cannot, the oath to the Constitution is above all. Putting your loyalty to a politician before that oath is illegal and treason. Okay. So remember, maintaining the rule of law. Okay. I was reading about the erosion of the rule of law. See, the problem is that nobody's held accountable for that. Penalties for violating the rule of law vary widely depending on the specific offenses, ranging from civil penalties like fines and damages to criminal penalties such as imprisonment, and include other consequences like loss of privileges and permanent disqualification from holding office. Consequences are determined by the severity and the nature of the violation and can be significantly higher for more serious intentional offenses, such as those involving bribery, corruption, or causing harm or death. Criminal penalties, imprisonment can range from a few years to life depending on the crime. Fines, financial penalties, they can be substantial, sometimes reaching hundreds of thousands of dollars. Probation, a court-supervised period of good behavior for alternative or addition to incarceration. Criminal record, a permanent record that can impact future employment on other opportunities. Civil penalties, fine, monetary penalties assessed by the government or the court. Damages, financial compensation paid to the victims of the violation, requiring the offender to pay back victims for losses they suffered. Other financial payments can include paying the other party's attorney fees. Administrative and professional penalties, loss of civil rights. In some cases, conviction can lead to the loss of rights such as voting or holding public office. Professional sanctions for public officials. Penalties can include censure, suspension, or permanent disqualification from holding a public position. Loss of professional license. A conviction of violation can lead to the suspension or revocation of professional license. Court sanctions. Judge can impose sanctions for violating court rules such as fines, orders, pay fees, or even dismiss the cases. And I told you, the judge can dismiss the case on if your right to a quick and speedy trial is violated. Federal cases, it's 70 days. So if you didn't go to trial within 70 days from your indictment, then the case is tossed. It gets thrown out. You can literally get yourself out of prison if that was violated. The quick and speedy trial clause in Illinois, I forgot, 120 days, 90 days. It depends on whether if you're incarcerated or if you're out on bond. Okay, but that often happens. And effective assistance counsel, that's rare, and that's described in the Rules of Professional Conduct and the Code of Judicial Conduct. Effective assistance counsel is a double-edged sword and cuts every which way you swing that in a court of law. And if nobody abides by or enforces the Rules of Professional Conduct and the Code of Judicial Conduct, they are legally required to report that misconduct. Failure to report that misconduct is misconduct in itself. Since nobody reports misconduct on each other or themselves because they are legally required to report themselves as well, everybody's guilty of deprivation of rights, which is effective assistance of counsel. And since nobody reported each other or themselves, quite easily proves a conspiracy against rights under the color of law, thus violating the rule of law. Factors including penalties, severity of violations, more serious and harmful offenses can result in more severe penalties. Intent, the degree to which the violation was intentional, plays a significant role in determining the penalty. History of prior offenses, a pattern of misconduct or prior violations can lead to harsher penalties. Harm caused, violations that cause death or serious injury can carry the most severe penalties. Okay. So penalties for violating the rule of law. See, there's penalties for violating the rule of law. It's what they mean by, I'm guessing, the rule of law is eroding, is people are violating the rule of law and nobody's doing nothing about it. Now, if we just lock up everybody that violates the rule of law, according to the law, then who would violate it? Okay, so let's go to the rule of law. The rule of law is a principle that everyone, including the government, is accountable under publicly promulgated, equally enforced, and independently adjudicated laws. This ensures that power is constrained, not arbitrary, and the legal process are fair, transparent, and consistent with human rights. It promotes stability in order by holding all members of society equal subject to the law. Key principles, accountability. That's what everybody wants. Accountability with our public servants. Nobody's suffering the penalties for violating all these laws. The letter of the law. We'll get to that in a minute. Accountability. All individuals, institutions, and titles, including those of government, are accountable to the law. Fair and stable laws. The legal system is based on laws that are public, understandable, stable, and fairly applied. Seriously, that's the law. That's not happening, but this is equal application. Law is enforced equally for everyone without discrimination based on factors like race, gender, or status. Well, there's statistics out there showing that's not happening. People use the statistics as well as the law. Independent adjudication, legal disputes are resolved by impartial judges and legal process that are accessible to all. Everybody has a right to a public trial, and right now, especially in family court where children are being taken away, they're denying people access. They're denying the public access. Immigration court, behind closed doors, denied public access. That is not in the public interest. That is in the interest of the power. I took a two-pronged approach on that. Two fronts on how illegal that is. Okay. But there's still more if you go over the rules and the codes. Okay. Protection of rights, the rule of law is consistent with international human rights principles, secure fundamental rights of all members of society. Functions and importance. Shapes power, determines how power is exercised, constrained, and held accountable. Prevents arbitrary power, prevents the government from acting arbitrary, and protects against the arbitrary exercise of power. Basically, abuse of power, protects you from abuse of power. Promotes trust, fair process like democratic elections with established rules, build public trust in the system. Foundation for democracy is fundamental component of democratic society, ensuring accountability and protecting individual freedoms. Okay, the rule of law. Okay, so, what the rule of law, I told you the penalties. So the only thing I can figure out when these lawyers and judges and politicians, political pundits, legal pundits on television, the rule of law is eroding, is because nobody's being charged for violating the rule of law. Nobody's going to jail. Nobody's getting locked up. Nobody's getting reimbursed for having their birthrights violated. Okay, um, people always argue with me about the letter of the law. And usually it was lawyers. So let's talk about a violation of the letter of the law is a failure to follow the precise lettering, wording of the rule or statute, as opposed to the underlying intent of the spirit of the law. Example including speeding, or a landlord leaving a tenant's evicted belongings on the curb. Even if the underlying spirit might be that the person shouldn't cause a public nuisance, violating the letter of the law can have legal consequences. It is often clear-cut infringement that can be punished regardless of specific circumstances. Letter versus the spirit of the law. Letter of the law refers to the exact written word of the law. It is a strict and literal interpretation, like a formal code of regulation. Spirit of the law refers to the intended purpose or goal behind the law's creation. That is often more subjective and can be debated or interpreted differently. And when I use the letter of the law, I always incite the letter of the law so that in the spirit of the law, we all see, say, and hear the same thing. People don't understand that it's a symbiotic relationship when it comes to the rule of law and the letter of law, especially when it comes to interpreting the Constitution, the rules of professional conduct, the code of judicial conduct. It's far too often somebody has tried to reinterpret these laws, which is ridiculous, and they used to get upset when I'd hold them to the letter of the law and then remind them the penalties for violating the letter of the law, because saying other than what is written is disinformation, and that's illegal. Okay, penalties for disinformation vary on jurisdiction and contents, ranging from social media account restrictions and civil penalties to criminal charges like fines, imprisonment, even life sentences. If disinformation leads to serious bodily injury or death, the specific penalties depends on the nature of disinformation, such as to whether it constitutes an hoax, disinformation, incitement, or threats. Penalties for specific types of disinformation hoaxes under U.S. law. Intentionally spreading false information can result in fines or imprisonment. The penalty increases significantly if the hoax leads to serious bodily injury, up to 20 years, or death, up to life. Defamation, sharing false statements that harm an individual's reputation, can lead to civil lawsuits and defamation. For defamation, penalties in these cases can include money damages. Threats. Conveying false information constitutes a serious threat, such as a false bomb that can be a felony offense, penalties up to 5 years in prison, fines. Incitement. International law prohibits laws that advocate for national, racial, or religious hatred that constitutes incitement or discrimination, hostility, or violence. Penalties for social media platforms, account actions. Social media platforms like Facebook may take actions against accounts that repeatedly share content that has been rated as false by fact checkers. I know you people don't like fact checkers, but I mean, that's what I'm all about. But I'm very specific in what I do. I fact check laws. And I just read them to you, and I tell you word for word, to the letter, And I'm actually letting you know why. If I was a lawyer and a judge, and if I violated a letter of the law when I interpreted the laws to you, I'd be breaking the law in so many ways. I would be violating the oath of public service, the oath I took as his attorney. I'll be violating the letter of the law. You know, I would be violating. This just that's disinformation. There's so many laws we could go over. Factors including penalties, intent, the intent behind spreading the disinformation office. Key factor, for instance, a false statement about a public figure cannot be a basis of defamation suit unless it can be proven that a statement was made with actual malice, with knowledge that it was false, with reckless disregard for whether it was false or not. Yeah, so I mean, you go on television and you're in public service and you telling lies and knowing they're lies, well, with knowledge that it was false or reckless disregard for whether it was false or not. Harm caused, the extent of the harm caused by the disinformation is a major factor in determining the penalty. Jurisdictional laws and penalties disinformation vary on country and state. Okay, so there's a lot of laws, there's nobody's enforcing out there. That's all I'm just trying to do. Tackling the impact of fake news. Well, a lot of people literally, I did a video where I was watching Congress, House, Senate, they were making votes on this and that. And a lot of things they were saying, I was reading to when they were talking about the public interest. It's mandatory that everybody in public service do what's in the public interest. It's the law. Not in self-interest, interest of the bar, not in parochial interest, and definitely not in the interest of Wall Street. Basic obligations of public service involve a duty to the public requiring officials to prioritize loyalty to Constitution, laws, and ethical principles about private gain. Key obligations include acting impartially, avoiding conflicts of interest, not using public office for private benefit, and being accountable for their actions. Public service must also use resources responsibly, protect government property, and maintain the public trust through integrity and transparency. Core obligations of principle: loyalty, integrity, place loyalty to Constitution, laws, and ethical principles about personal gain. This includes upholding the integrity of the government and serving the public interest. And no matter what laws I read to people, it's going to always tell you serving the public interest. Average Joe and Joanne, John, Jane Q. Public. Act without bias and avoid giving preferential treatment to any private organization or individual. Conflict of interest: avoid financial interests that conflict with official duties, and refrain from using non-public government information for private gain. Stewardship: protect and serve government property and use resources responsibly, which include not making unauthorized commitments or promises. Accountability: disclose waste, fraud, or abuse to appropriate authorities and be accountable for actions. Legal and ethical adhere to all relevant law and regulations, including those concerning equal opportunity. Avoid actions and create an appearance of violating the law or ethical standards. Public trust: foster and maintain public confidence in the government's integrity and impartiality through open and transparent conduct. Okay, so you can file complaints for anybody that violates basic obligations of public service. Find it on the U.S. Department of Interior. See over here, CFR.gov. This is Office of Government Ethics, Department of Justice. So you can also, It's going to tell you about all these ethical violations. But they won't do nothing unless you file a complaint. When I was a kid, they used to call that red tape. So before they'll hold a public official, a public servant accountable to the law, you got to file a complaint. Me and you, all somebody do is got to point the finger. And you're in jail and got to get a lawyer. And U.S. Fish and Wildlife, Ethics and Public Service. Public service is a public trust, quotes the obligations, public service. That's why, you want to, I mean, they all say the same thing. That's not big enough for me to read. Let's go to the DOJ website. Public service is a public trust requiring employees to place loyalty to the Constitution and laws, ethical principles above private gain. Employees shall not hold financial interests that conflict with their conscientious performance of duties. Employers shall not engage in financial transactions using non-public government information to allow improper use of such information or further any private interests. Okay, so it's going to tell you a whole lot more that you're not supposed to be doing, okay? I advise you to come take a look. It's not that, look at it, it's not that long. It's not that long. Obligations of public service. 14 general principles of ethical conduct. Okay, so there's a lot of things that politicians are doing, they shouldn't be doing. Wall Street shouldn't be making decisions. But there you go. Okay, I'm gonna cut this off. I don't know how long I've been talking, but TikTok only allows my videos for an hour. So thank you and good night. May your Creator always be with you and rain many blessings. God bless.